ironically enough, we'd set this meeting a few weeks ago, but with respect to our case in the federal court, the second level, the Justice Russell, who heard the appeal from the protonotary, who struck the entire action for not being justiciable, made his ruling yesterday. I got it late Thursday night, but I saw it yesterday, and I analyzed it for the purpose of this meeting. I have here 25 double-sided copies of the ruling, if anybody wants to take one. And then I have I didn't know how many people would be here, but I have a single side. I'll leave with Anne. If anybody else wants a copy, maybe you can see to it, Anne, that they get it. And I'll talk briefly about it. There's a bit of bad news, but mostly good news. The bad news is that we all knew we'd have to go to the Court of Appeal. The government lawyer is out of town till May 8th, so I haven't been able to speak with them to see if they're appealing part of the ruling. On the issue of whether or not the declarations that we sought to say that the government and the finance minister were exceeding the parameters of the Bank of Canada statute and the Constitution, Justice Russell said those are justiciable. They can proceed with those. You know, the courts decide this all the time, and the court's not going to be deciding whether the particular minutiae of their socioeconomic choices are to be reviewed, but whether or not they're staying within their statutory or constitutional parameters. And so that's the good news, because the lower court had completely struck it on the basis that nothing was justiciable, and he's reversed that ruling. And if you recall, basically that was the main thrust of to our challenge, is to get a declaration and a clarification of whether or not they're properly following the statute and the Constitution in exercising the powers of the Bank of Canada. Justice Russell agreed with me that when the protonotary interpreted the may as not giving rise to a duty, that was beyond his jurisdiction to do. He said that has to be for the trial judge after evidence goes in. So I'll briefly go through the decision and explain what the ruling was, and then I'll take questions. I'll take questions from anybody who has any. Let me say, in fairness to this judge, who is a very intelligent and capable judge, that most of his, I'd say virtually all of his setting out of the facts and the issues are really fairly done. So at paragraphs 1 to 13, pages 1 to 9 of the decision, he accurately sets out what the claim and the relief sought is, and he doesn't pull away from basically setting out what the plaintiff's allegations are with respect to how they've hijacked Canada's financial agenda and Canada's sovereignty. So he sets that out. Many other judges might have simply held back and not elaborated on the facts of what the allegations are, knowing that the decision is going to be published and is going to be out there. But the court didn't do that. If you read it for yourself, you'll see that there's a fair recital of what we're asking for and what the allegations are. And then he fairly sets out what the decision of the protonotary was down below at paragraphs 14 to 23, pages 9 to 13 of the decision. And then he goes through the scope of review, and then he sets out the statutory provisions, and then he sets out the arguments at paragraphs 29 to 44 that I made, and at paragraphs 45 to 62, the arguments that the government lawyer made. And again, with the exception of one minor detail, these were also fairly set out accurately, which, you know, it may be surprising to you sitting there thinking, well, what's the big deal? Isn't the judge supposed to do that? And most judges don't do that, because then they can go off and decide an issue that wasn't really argued. This judge actually stuck to the rigor of his duty and actually did that. The only minor flaw in his recitation of the facts is that he cites the protonotary in saying that you can't have a discrimination claim when all Canadian citizens within Canada are treated alike. And I made it very clear, and it's clear in the pleading and during argument, that not only are Canadians discriminated against with respect to private foreign bankers, but they're also discriminated against with respect to private domestic bankers too, who loan money to the government at interest rates that we shouldn't be paying. So apart from that, his review of the facts, the allegations, and the arguments are fairly accurate. And then he goes through his analysis, and he starts his analysis at paragraph 63 to 97, pages 37 to 56 of his ruling. He starts out by saying that neither I nor the government lawyer disagree on what the law on a motion to strike is, which is true. It's just that we disagree on whether or not it was properly applied in this case. So then he goes to the first issue of justiciability, and if you recall, justiciability is an issue that the courts look at to see whether or not the court has the wherewithal or the capacity to look at the legal issue. Throughout the decision, when he says Bank Act, he doesn't really mean the Bank Act, which is separate from the Bank of Canada Act. He's referring to the Bank of Canada Act. And Section 18 in particular had to be read in a permissive way. The obverse of his reasoning would seem to suggest that if the Act contains a, quote, legislative imperative, then this may well be a justiciable matter for the court. The full import of the Act and what it requires of Canada and those ministers and officials who act or don't act in accordance with the Act is at the heart of this dispute. Hence, in order to reach his conclusions on the non-justiciability, the protonotary decided the principal legal issue at stake in these proceedings. I do not accept the plaintiff's argument that the statutory interpretation cannot be dealt with on a motion to strike, and then he cites a federal court case. To strike, and then citing a federal court case, he could have cited the Supreme Court cases, which he later does. He says, however, it may be better to leave a complex matter of statutory interpretation for argument at trial, and the fact that an issue is contentious does not necessarily make it complex. Protonotary Alto felt that, quote, may in Section 18 had an obvious literal meaning that could be dealt with on a motion to strike. My reason for differing from the protonotary on justiciability is that in addition to breaches of the Bank Act, the claim is also based upon other alleged constitutional breaches, and even if Section 18 of the Act is permissive, this does not dispose of the allegations of improper handing off to international institutions. May is usually permissive, but this is not invariably so, and full legal argument on a full evidentiary record is required before the court can decide what the Bank Act requires of the government and those involved in applying and interpreting that statute. And then he cites the Supreme Court of Canada case in Dumont, which I put before him, saying that issues as to the proper interpretation of relevant provisions and the effect upon them would appear to be better determined at trial, where a proper factual case can be laid. And in paragraph 73, citing another Supreme Court case in Imperial Tobacco, he says, the question is whether, considered in the context of the law and the litigation process, the claim has no reasonable chance of success. It meant to encourage the court in a motion to strike to decide points of statutory interpretation before hearing the evidence and full argument based upon that evidence. It may well be, however, that at some appropriate time in these proceedings, this important matter will lend itself to summary determination. What he's saying is, if you have the facts required, it doesn't have to be a full-blown trial. He's not determining that. You can determine this up the road, but not on this preliminary juncture before on a motion to strike. Then in paragraph 74, he says, in addition, as I think the claim makes clear, the plaintiffs clearly dispute and challenge certain socioeconomic policy decisions that have been taken by the government and others with respect to the Bank Act. It is also clear that plaintiffs would like the government and others to make policy choices that are more in line with the plaintiffs' views of how to interpret and apply the Bank Act. In my view, however, the principal relief sought in this claim, the declaratory relief, does not require the court to adjudicate competing policy choices. It requires the court to assess whether Canada, the ministers and the officials identified have acted and continue to act in accordance with the Act and their constitutional obligations. In other words, there is, in my view, a sufficient legal component to the claim that will allow the court to assess government action against the Bank Act and the Constitution without having to review policy. By that he means the nitty-gritty. And then paragraph 75, He says, the difficult boundary between what a court should and should not decide will arise time and time again in a case like the present. However, the issue is not whether the court should mandate the government and the bank to adopt economic positions espoused and advocated by the plaintiffs, nor will the court be deciding whether a particular policy is financially or economically fallacious, although this accusation does appear in the claim. In my view, the court is being asked to decide whether particular policies and acts are in accordance with the Bank Act and the Constitution. If justiciability is a matter of appropriateness, then the court is the appropriate forum to decide this kind of issue. In fact, the court does this all the time. The Supreme Court of Canada has made it clear that the Parliament of Canada and Executive cannot advocate the function. See Wheat Board. These are the old World War II War Measures Act cases that I put before Justice Russell. And he also cites the Quebec secession referendum, saying that the executive and other government actors are bound by constitutional norms. And then finally, paragraph 76, he says, so as regards the declaratory relief in the claim, it is my view that the matters raised could be justiciable and appropriate for consideration by the court. Should the plaintiff stray across the line into policy, they will be controlled by the court. There's a difference between the court declaring that the government or the governor or the minister should pursue a particular policy and a declaration as to whether the policy or policies have pursued or are compliant with the Bank Act and the Constitution. The facts are pleaded on those issues. Subject to what I have to say about other aspects of the claim, the plaintiff should be allowed to go forward, call their evidence, and attempt to make their case. It cannot be said, in my view, that it is plain and obvious on the facts pleaded that the action cannot succeed as regards this aspect of the claim. And even if Section 18 of the Bank Act is interpreted as purely permissive, that does not decide the issue raised in the claim that Canada has obviated crucial aspects of the Bank Act and has subverted or abdicated constitutional obligations by making itself subservient to private international institutions. Okay?